Welcome to lesson 20 of Your Journey of Life, which is about employment rights and responsibilities. So first, let's consider this. How many hours do workers over the age of 18 in the UK have to work to be entitled to an uninterrupted 20-minute rest break? Is it 2 hours, 4 hours, 6 hours, or 8 hours? The correct answer is 6 hours. Younger workers, who are between 16 and 18 years, are entitled to a 30-minute rest break if they work more than 4.5 hours. There is an entitlement in the UK to something known as daily rest, which is the right to 11 hours rest between workdays. For instance, if you finished work at 8 p.m, you can't start work until 7 a.m. the next day. There is also an entitlement in the UK to weekly rest, and this is an uninterrupted 24 hours without working each week, or an uninterrupted 48 hours without working each fortnight. With breaks at work, daily rest, and weekly rest, there are some plausible exceptions. So here's a task for you. Investigate the workers who are not entitled to the 3 general types of rest break. Okay, let's take a look at the answers. If you are in the armed forces or the emergency services and are dealing with an exceptional catastrophe or disaster, you will not be entitled to the 3 general types of rest break. If you have a job where you freely choose your own hours, such as a company director, you are not entitled to the 3 types of break. And finally, mobile workers. These are people who work in air, road and sea travel, and they are covered by special rules that give them more regular rest breaks so that passengers are not put at risk. Now let's look at holiday entitlements. Almost all workers are entitled to 5.6 weeks paid holiday a year. This is known as statutory annual leave entitlement. For people who work full-time, 5 days a week, this equates to 28 days a year. If you work part-time, for example 3 days a week, you are entitled to at least 16.8 days. This is worked out as 3 times 5.6 weeks. It's also important to note that an employer can include bank holidays as part of your 28 days off. But also, it is not an entitlement that they have to be given as paid leave. Your employment rights also state that you can still build up holiday entitlement during any period of sickness or maternity or paternity leave. Next, let's consider the minimum wage. In the UK, there is a set minimum rate of pay per hour, which can vary depending upon your age and the type of work you do. Your task now is to search for the national minimum wage for each of the ages and scenarios on the screen, and also fill them out on your worksheet. As of April 2023, the national minimum wage for an apprentice and those under 18 years old is £5.28. Age 18 to 20 is £7.49. 21 to 22 is £10.18. And the national minimum wage for those over 23 years old is £10.42. Now, we want you to imagine that you are earning minimum wage for an 18 to 20-year-old, working full-time at 37.5 hours a week. Work out your monthly wages and what your monthly take-home pay would be. You may need to refer back to some of the lessons earlier on in your journey of life to remind yourselves of the required deductions such as national insurance and income tax. Let's check your answers. The minimum wage for an 18 to 20-year-old is £7.49 an hour, which equals £280.88 per week, or £14,605.50 per year, working 37.5 hours per week. Working out your take-home pay after your deductions. National insurance was 12% of earnings above £242 per week. So, 12% of £38.88, which is £4.67 a week. Remembering that income tax you pay 20% above £12,570. So you only need to pay 20% on the £2,035.50 above this, which works out at £407.10 per year, and just £7.83 per week. Therefore, after deductions, it would leave your weekly take-home pay as £268.38 and monthly as £1,073.52. An independent benefits checker reveals that if you are earning the minimum wage at 18, currently £7.49, you are not entitled to any benefits, including universal credit. So using an online property search website, look for somewhere that you could rent if you had to move out of your parents' house and could not stay with friends. Now remember, you still have food and other bills that you need to pay for, so see what your best accommodation option would be. Start with the area you would like to live in and expand the search area until you find suitable accommodation for your minimum wage pay. Okay, let's return to employment rights and responsibilities. It's time to consider dismissal from work. Your employer will provide you with a contract and maybe a staff handbook that outlines any behaviour which could cause you to lose your job. But what happens if you're unfairly dismissed? In order to decide if you've been unfairly dismissed, the reason for your dismissal must be considered. So here's a task for you. Consider the following reasons and sort them into the correct categories on your worksheet as either a fair reason for dismissal or an unfair reason for dismissal. Okay, let's consider some of the fair reasons for dismissal. Not being able to keep up with a new computer system at work despite numerous training courses. If you develop an illness, that means you can no longer do your job. Gross misconduct, such as assaulting a colleague. If a factory burns down and you can no longer work there. Or finally, if you are sent to prison. These are all considered fair reasons for dismissal. Those which might constitute unfair dismissal include if you request to change from full-time to part-time, if you refuse to give up your daily rest breaks, if you miss work to attend jury service, if you were dismissed because you requested leave to adopt a child or to embark on maternity or paternity leave, or if you joined a trade union after a row with your boss. These would all be considered unfair reasons for dismissal. It's also worth noting that as of April 2011, an employer is no longer allowed to enact compulsory retirement. It used to be that employers could force workers to retire at 65. However, there is no legal retirement age, and employers can no longer force their employees to retire at a particular age. It's up to you to decide when you want to stop working. There are some situations where an employer can force you to retire by law, but they must give a good reason why. For instance, if your job requires you to have a certain level of mental or physical ability, or if there is an age limit set in law. Now let's consider redundancies. Redundancy usually happens when there is no longer a need for someone to do your work. For instance, if the business is closing down, or the way that the business operates needs to change significantly. Your employer should select employees for redundancy in a fair way, and they must follow the business redundancy policy and the conditions stated in your employment contract. Your employer also has a duty to consider if there are any suitable alternative jobs in the company. Before you are made redundant, if a suitable job exists, it should be made available to you. If you were chosen for redundancy due to any reason involving the protected characteristics, it could be considered unfair dismissal. This could include age, gender, sexual orientation, and race. If you feel you were selected for redundancy unfairly, you can appeal, and unfair dismissal claims could go to an employment tribunal. If you are made redundant, the amount of pay you get is usually worked out by how long you've worked for the company. You won't be entitled to any redundancy pay if your employer offers to keep you on, or if they offer you a suitable alternative position which you then refuse. So that brings us to the end of employment rights